Good afternoon. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note, any website or email that I mentioned will be posted in the chat. For those seeking business license assistance, you can visit the Small Business Center here at City Hall or call 312-74-GO-BIZ. Also, business license can be applied for or renewed online at chicagobusinessdirect.org. If you are a part of the BACP Entrepreneur Certificate Program, you can get credit for joining this webinar by sending an email to bacpoutreach@cityofchicago.org. To learn more about this program, please visit chicago.gov/business education. This webinar is being recorded and will be available at youtube.com/Chicago BACP. We encourage all attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of this presentation. Today's webinar is entitled Title VI Worker Protection, presented by the Director of Office of Labor Standards, Mr. Andy Fox. I will now turn this webinar over to Andy for us to begin.
Thank you, Stella. Hi, everybody. I'll try not to look down because that's where the camera is. Welcome to the Title VI Worker Protection webinar. Now, my goal today is to go over emerging trends and investigations. But first, if at all possible, I would like you all to just, if you feel free enough to share kind of your, either your job or your interest or why you're here. You know, like, I'm Andy, I'm the director of OLS, or I'm Susie, I'm a business owner, I'm Harold, I'm a fry cook, and I think they're stealing my wages. Just throw that in the chat and I'll try to monitor it. Throughout the presentation, you can post questions in the chat. I'll try my best to monitor it as we go, but you know, if you could just do me this favor, chat in questions that relate to the slide we're on. We're going to go over a few things and then we'll get busy. So without further ado, let's begin. So I called this emerging trends, emerging issues and investigations. The Office of Labor Standards has enforcement power over the minimum wage, paid sick leave, Fair Workweek Ordinance, and the retaliation sections in each of those. There's an anti-retaliation ordinance related to COVID-19. There's an anti-retaliation ordinance related to the vaccines. There's also the domestic worker contract requirement, and under minimum wage and paid sick leave ordinance, the umbrella, there's a wage theft section. Sorry, my voice is a little dry. Let's get to work. So to introduce the office, I'm the director, I'm an attorney. We've got 4 investigators, we've had up to 5. We're hiring additional staff to be able to handle and process and keep timely with complaints. When you think of the Office of Labor Standards and worker protections, just wrap your arms around the geography of the city of Chicago. If work is performed in the city of Chicago, it's Chicago work. So if you have a business in Joliet, you send your workers to Chicago, Chicago work. So the home rule authority of cities in Illinois is based on the statutory construction that cities larger than 250,000 people can establish certain protective functions. One of those is to regulate wages and hours. So the Office of Labor Standards was created in 2019, and the office is charged with protecting workers in those areas. It's to make sure that employers are in compliance, and we're housed in the Department of Business Affairs and Consumer Protection. So licensees, business owners in the city of Chicago, you know, you've got a license or you're seeking a license, you're an entrepreneur, you're about to grow a business, you go to BACP for counseling, for contracts, for advice, not contracts. You join your chamber and you're looking to get certain funding to help you out become a business. You attend the business webinar and say, okay, I'm interested in making sure that I pay my workers and there aren't any issues. This webinar is designed to help employers understand what the labor laws are in Chicago. That's the office. We also work with other offices, and I'll talk to that briefly. So if I have another slide on emerging trends introduction. Oh, there you go. Emerging trends, emerging issues. There is a lot going on with workers. I mean, think back to when society was shut down, closed, and it impacted all 77 neighborhoods all over the city, big and small. Some big places closed, some small places closed, some places that have been around for 50 or 100 years closed. As we reopen and the pandemic kind of waned, we now see businesses opening, and new and old businesses are hiring people back. Business owners may or may not know that each year in July, the minimum wage increases. New businesses who have tipped workers, and you think, well, I don't have tipped workers. If a worker receives more than $30 in gratuities each month, they're tipped workers. There are rules that impact tip workers. And if you take tips from the workers, you might be charged with wage theft. So we're going to talk a little bit about that. I'll try to give some colorful examples. My goal is to make sure that you do not doze off, fall asleep, and become numb to what I'm talking about. We'll try to put some color. I'll exaggerate for effect so that we can get some learning opportunities here. Let me see. Looks like we have primarily business owners. And you're the good guys and gals. Good guys in a way that means everybody. Paid sick leave investigations, it's our next topic. Some businesses don't believe that they have to give sick leave. There are a couple different reasons why. I can go into that more, but some people have no sick leave at all. Why only have part-time employees? Well, if the work is performed in Chicago and it meets certain things, we don't distinguish between part-time and full-time. You might accrue less sick leave over a period of time, but you accrue sick leave. And people are entitled to sick leave. And so what our office does is we try to make the workers whole. We don't want to punish and shut down and fine and tax people. We want you to thrive. Without business, there are no workers, and vice versa. They feed each other. We want there to be fair jobs. We want there to be equity in hiring. We want people to be treated fairly, documented and undocumented. Because this is a welcoming city. We're not interested in citizenship status. If you're paying people in cash, you better pay them the minimum wage. Because if they call us and then you threaten deportation or you threaten some immigration action, you could be in more trouble than I have power to enforce. Think of that. So, and we've seen it happen. It's not the 80s, it's not the 90s, it's 2022. So in this wonderful city with all 77 neighborhoods, you business owners who are trying to get up, stay up, and succeed and become the next great thing, you want to make sure that you're in compliance. That's why you're here. Those that should be here are probably not. Those unlicensed businesses setting up shop and paying people in cash, taking their tips, doing unsavory acts might not be present on this call. That's okay. We're going to educate you all. We're going to educate anyone who's listening and empower workers and employers to comply. There are also the Fair Work Week investigations. I'm going to give an overview of that. It's a little more complex because it really has to do with the size of the businesses. Larger businesses have the resources, the ability to hire lawyers to set up a regime that can make sure that they're in compliance. It's about scheduling and giving advance notice of schedules. It's about when you change people's schedules without notice, cut hours, extend hours, you might owe people something called predictability pay, which is a premium pay. It's an extra pay due. It's 1 hour of work, 1 hour at the regular rate of pay. Now, point number 4 is managers, managers, managers. So you're a great business owner. You set up this wonderful regime for minimum wage, paid sick leave, your payroll reflects everything. You've got an employee handbook and manual. Everybody signs off on it. But it all goes to the manager. The manager is the one that adversely impacts an employee's livelihood. Oh, you don't want to take this extra shift. You don't want to do overtime. Cool. That's so cool. I know I hired you to work 40 hours. Next week you got 10. You know what? Oh, you want to complain about whether or not you get sick leave? Tell you what, take out the garbage. Punitive actions designed to threaten, harass, deter those from exercising rights are usually in the hands of managers. So you might look great on paper. We all do. I look pretty good on paper. But when you meet me, you know, oh my land, it's the manager that's turnkey in many of these moments between the business and the workers. And that's where morale is. Everyone complains it's really hard to get people to stay at work. It's hard to hire. You have to pay like $18 an hour to get fast food workers, according to one owner I worked with recently. Yeah, it is hard to get. So you want to keep them and treat them well. And some of them have negotiating power, more than you would expect from a low wage worker, more than you would expect from someone who brings you profit. Yes, workers are empowered to exercise their voices, and sometimes they want to work from home, and sometimes they want benefits, and sometimes they want those things that we help set the bar for. City of Chicago, through Home Rule Authority, I'm extending my arms out, is that we set the minimum bar. It's the minimum. You can do much more. Another trend is that we have recently opened up dialogue and communication with the Illinois Department of Labor. If they're paying the state minimum wage and you should have been paying the city minimum wage, they make findings and violations, and they settle with you for the state minimum wage, they're going to refer the case over to us, and we're going to make you pay the entire Chicago minimum wage if the work is performed in Chicago. The U.S. Department of Labor, a very agile, we think of the federal government, oh, it's this large bureaucracy. No, 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 no. Recently, we had a case in my neighborhood in Pilsen, which people in Pilsen believe it's the heart of the world, the center of the universe. It is in my eyes. But in Pilsen, there was a business, and I noticed that certain employees were coming in and they seemed really young. And I noticed there was this giant tip jar, but I was really concerned that it might not be shared among the workers, and or the manager was taking the tips. So the USDOL, a friend of mine who we have an MOU with, said, you know what, I'll just send a couple investigators over. They shut the business down. They conducted 14 interviews, and that business is now involved in a very, let's call it resource intense investigation for wage and hour violations. And those undocumented workers, those young boys that are possibly trafficked, probably need their own counsel to protect them. We could intervene and ask them through their attorneys to file a T or a U visa. A T visa is about trafficking. A U visa is a witness to some sort of labor or criminal violation, could get immigration status to protect them while they're participating in this investigation or criminal investigation. There's also the Attorney General's Workplace Rights Bureau. A couple of brilliant attorneys are there. They've worked in the private sector. Now they're working for workers. Now they're working in the Attorney General's office, and they are quick to act and do all their own investigations on their own. The Cook County enforcement entities. There was a time when Cook County did not have as vigorous an investigative process. They do now. So there's the city of Chicago, it ends. And then there's the county. So the county has its own minimum wage, its own rules about payment and how much and when it changes. Pay attention, because the counties, some of the municipalities have taken themselves out of enforcement, but that's county by county. Then there are the worker centers. We've partnered with the worker centers. Last year, we had a $100,000 grant to drive education outreach related to domestic workers. This year, it looks like we'll be funded again with $100,000, and we look to partner with people on the ground who can develop trust relationships with workers. We've also been collaborating with researchers and tech firms. This very week, we're going to a convening, which I'm old. So a convening is where you take a bunch of researchers and lawyers and practitioners and fellows, the best and brightest, not me, the best and brightest to study. Okay, so we've got these complex investigations. How can we use data? Can we text the workers? Can we use spreadsheets? Can we use algorithms? How do we use geolocation software in our subpoenas to get information about where and when and how the workers work? Believe it, it's coming. Next, and you can post any questions as we go through. And if I'm talking too fast, remind me and I'll try to slow down. So, of the more important topics today, I just want to, you know this, but it doesn't hurt to restate it. Any employer who fails to timely pay a covered employee in accordance with this chapter, or in accordance with any wage agreement between the employer and covered employee above the threshold as required in this chapter, shall have committed wage theft. The wage theft, it sounds, you think of wage theft, you think, wow, I didn't get paid. I worked there for 2 years. They didn't pay me those last 2 weeks. Boom. Wage theft. Wage theft includes non-payment of wages required for work performed. It also includes paid time off. So you don't pay sick leave when they're due sick leave, it's a form of wage theft. Whether legislatively or contractually required and contractually required benefits to the covered employee. Now, covered employee is a loaded, it's not loaded, it's a definitional term. Covered employees are generally W-2 employees. Generally, the city of Chicago wage and hour, labor laws, worker protections don't apply to independent contractors generally, except for one population, domestic workers. However, if they're undocumented workers and they don't file a W-2 or 1099, we can find they are actually employees. So if you're hiring Venezuelan or other migrant workers and paying in cash, and we have records of what they were paid, you can believe I'll be handing out at the migrant centers information about how to document wages and hours and how many days you worked and who paid you. Not that I want them to get into immigration jeopardy, but keep records of what they have. If we have information that shows that people are not getting the full minimum wage as defined in Chicago, it's wage theft. And then there's the timely payment of wages. We've had very nice business owners. Mohammed, I did not say tech firm, I don't think. The timely pay of wages is potentially an issue. Businesses starting up and they're Venmoing people. If you're not getting deductions from your wages, it's a problem. And as a worker, you need to say, listen, I need to be paid so that my deductions, if at some point you begin filing a W-2, a W-4 for me, and then I've got wages that I was paid in cash, then that works a detriment to me. We've got a case right now where there's some cash payments. We sent out a subpoena because we talked to the workers. I'm getting paid in cash. Certain employees are getting large amounts of cash. There's just a lot of unsavory acts going on. It's a franchise. So the global entity is huge, but it's a franchise. The franchise owner has allegedly been paying in cash, and certain employees are living at the house of the franchise owner. And so there might be some trafficking going on. All the bells and whistles are going off. Now to the manager and or the regional manager, like, hey, I need you to sign this W-4 and I want to begin deducting wages. And then the manager's like, hey, well, that's great, but you've been paying me in checks for the last 2 months, or you haven't been paying me on a timely basis for the last 2 months. Then I would think, one, it's wage theft. Two, record retention. You gotta have records, and the records should include deductions and wages. Surina asks, are commission-based employees covered under the definition of covered employees? I'll have to pull up the statute. There is a little, well, for purposes of paid sick leave, if you work more hours, then it really, you just accrue 1 hour for 4 hours worked. I don't know that we distinguish by commission-based employees as covered employees. You're an employee if you file a W-2. That's generally the way. And then so we look to whether or not you pay the minimum wage, and we break it down by time. But commission-based, we don't break it down by time. It takes a little analysis. So I have to pull up the statute and get that specific section. And I don't know if I have that right now. But hopefully before the end of seminar, we'll get to it. Sudhina. Let's continue on wage theft. A covered employee may file a claim with the Office of Labor Standards or in a civil action, but not both. So we had an employee who believed that they were not getting paid the full minimum wage, and or they were not getting paid sick leave paid to them. So they believed that they had a wage theft action. They went to the Illinois Department of Labor and filed a wage theft claim, which is within your power. But the wages that they can enforce are lower than Chicago minimum wage. So I'm like, oh, wow. They can only enforce whatever the state minimum wage is. We can enforce, if depending on the employee count, $15.40 an hour. So they were like, well, I would much rather be with the Chicago Office of Labor Standards than the Illinois Department of Labor. Personal. So they withdrew their claim there, and then they filed their claim with us. the employer shall be liable to the covered employee for the amount of underpayments and shall also be liable for damages of Romanet I, Romanet 1, 2% of the amount of any such underpayments for each month following the date of payment during which such underpayments remain unpaid, or Romanet 2, the amount specified by the Illinois Wage Payment and Collection Act. Leave it to lawyers to make something simple confusing. Basically, if they owed you money from the last 2 years, we're going to take interest on it for each month at the rate of 2% per month. So they owe you $100 per month for 12 months, $1,200. We're going to take 2% per month following the date of payment during which such underpayments remain unpaid. Or we had to build this in. What if the Illinois Wage Payment and Collection Act calls for a higher percentage? 2% was approximately what the consumer price index was, so they tied it to 2%. Or if it goes up under the Illinois Wage Payment and Collection Act, then we would go to that higher amount. Right now, 2%. So what is wage theft? Let's just put it in plain speak. I'm a lawyer, but not your lawyer. Stealing, robbing, taking, robando. The 5-finger discount on my wages. Your employer takes all of you are, you're at a bar, a restaurant, like a burger joint. Everybody's getting tips. Even the bar backs are getting part of the tips. The servers, everybody's getting part of the tips. The owner takes all the tips and the credit cards and says, oh, you know what? I'm going to pay you once a month. Ooh, problem. The interaction of the definition of wage theft with the Fair Labor Standards Act is where we need to go. You can't steal people's tips. Tips are the property of the worker who earned them. Managers can never take tips. There can be tip pooling arrangements. So stealing or not paying wages, easy. You didn't pay me my wages. When I left, you made some cockamamie claim that you were charging me for some tools that I never had. Benefits, such as paid sick leave. You were supposed to give me sick leave and you didn't. Or in one instance, we've got domestic workers called out to do a job. You're calling them out to care for grandma, and they get out there and they're late. So the company says, oh, what? We're canceling. We're going to charge you for coming out. Cancellation fee. What if the worker says, you know what? I can't come today to take care of grandma. I'm sick. Isn't that COVID? I'm sick. They say, fine. You cancel with less than 48 hours, $50. You cancel with less than 10 hours, $100. That is a punitive deprivation of a right, which is your right to take sick leave. And then I'll show you the actual statute a couple slides later. But basically, if you take away people's benefits, it's wage theft. If you're not paying the overtime rate, we did a very interesting case. It was a local, it was a mercado / taqueria, a little village. The workers were saying, listen, I get paid by check. They were all undocumented, but I'm not interested in their citizenship status. They were undocumented, started talking to them, gained their trust, worked at the case. There were maybe 15 people in the restaurant. There were maybe 20 people in the supermarket. And the owner was paying regular rate, almost the minimum wage, but maybe $1 or $2 less. I mean, that's a violation. But he's paying less than minimum wage. So he owed them maybe $2,000 or $3,000 over a period of time. So I said, hey, you got to pay that gap. But when it came to overtime, he was paying them in cash, but he was paying them at the straight rate. And he was like, well, they wanted me to pay them in cash because they didn't want to report it to the revenue department. Yeah, but you have to pay them overtime rate if they're working overtime. It's cash, it's off the books. So the Office of Labor Standards says, just make them whole. Please make them whole and I'll reduce your fines. That's what we try to do. If it's really like a mea culpa moment. If we issue a subpoena and it turns out that, oh my gosh, I didn't know I wasn't able to tip pool with people that were managers. And so some of the money that was taken is owed to the workers. We say, make the workers whole. We'll reduce your fines. So the fine is this big and the fine goes down. You quickly and promptly recognize it Mea culpa, totally my fault. I paid ADP to put that on the wage records. They didn't. This is my fault. I'm gonna fix it. Fixes it, done. That's one of my very first cases in the office back in 2019 was a daycare owner. And it was alleged that they weren't getting sick leave, and they weren't. And it was alleged that they weren't getting the full minimum wage. And so she wrote to me in all caps. It looked like she typed it on her phone in all caps. Dear Mr. Fox, I'm really sorry. I did an analysis of what I owe the people for minimum wage. I've already paid that. I made those workers whole. And as for sick leave, let's meet and talk about it. So she came down to the office. This is before COVID. Came down to the office and we figured out what did you owe those people in back pay related to sick leave? And there's a calculation done by the Center for Disease Control that says in a year, approximately 28 hours per year are taken by employees that do work. So if I have sick leave, I usually take 28 hours. And so I say to employers, had they had it, it would have taken 28 hours. So I want you to pay them 28 hours times their rate of pay for that lost sick leave. You owe them that for 2019, 2020. And it's not like the workers don't want a giant payout. They don't want to become millionaires. They just want to be treated fair, as you do. Workers, employers, just tell me what to do and I will do it. Tell me what's fair. Tell me what's right and just. I will do it. So not paying the overtime rate, cash out the books, timely payment of wages. You can't pay them if it's a 2-week work cycle. You have to pay them at the end of 2 weeks. Every 2 weeks they should get paid. Every week they should get paid. If it's a monthly cycle, then it's 1 month. But you can't pay them irregular payments. And I know that's hard because meat is up, gas is up, everything is up. But if you can't afford to do right by your workers, don't build the economy on the backs of workers. Tips. Number 5, tips. It's almost like managers. More and more, we're seeing tips as a problem. At some it's like Starbucks. At some Starbucks, you can put a tip on there. At some places, it's automatic. At my little pizza joint in it's not Little Italy, we're on the other side. We're over by Tri-Taylor. We're on Taylor Street. When you go to check out, there's an optional tip. So I asked the workers, hey, this little tip I give you every day, at the end of the day, do you get tips? And they're like, what? They have no clue. What I would do is I would subpoena the records. What was paid and what were the tips, and show me the records of whether or not tipped workers got their tips. Do the people working the cashier box or working the front get their tips? Do people in the back sharing the tips? We've got a very high profile case we're working right now related to tips, and it's in a bar, a restaurant, and there's another one, it's a banquet facility. And so barbacks, servers, bartenders sometimes share in a tip pool. Now, barbacks aren't necessarily, and so sharing in a tip pool is something you should know. The workers have no clue what is paid into the business when the bill is submitted to the client. So the workers know that there are 14 tables and there are 42 wing setups and there's alcohol and there are charges. There's a fee for the banquet hall. So they know that these things exist. They don't see the prices. They just know what they have to set up. When it's paid, they don't know, was it 2,000, 3,000? Was it 500 for liquor and 400 for food? What was the fee for the space? And what did the customer pay? Because when you know what the customer paid, okay, so if I'm a server, what percentage was mine? Most bars and restaurants, at the end of the day, you get a payout, like a sheet. This is okay, liquor costs this much, food was this much, and you tip everybody out accordingly. Of course, in this entity, some people allege the bartenders are not paying out the barbacks, and sometimes the barbacks are complaining they're not getting enough of the tips. Everybody wants to know, why not be transparent with your tips? When you hide things from people, you got to wonder, what are you hiding? What's under the hood? Another emerging trend would be misclassification. Now, this is not within my jurisdiction. It's not. But people clamoring for justice say, wait a minute. I work as an independent contractor. I'm there for, like me, I used to be a bike messenger. Don't tell me. But I failed the MAP test. I worked for a now defunct entity called Cannonball Courier. I went in, I filled out the test. I said, you didn't really pass, dude. But whatever, go ahead. So I'm riding downtown Chicago. I was like Gomer Pyle, country boy in a big city on a borrowed mountain bike in the late 90s. It was raining. I was going on the one-ways and sidewalks. I was on Lower Wacker, and no one likes a bike messenger back in those days. That was before. I mean, I don't even know if I had a phone. I had a radio and a number, 31 to control, and they're squawking at me through a radio all the time. I was told I was an independent contractor. But every day I had a uniform, I had a vest, I had a radio, all my work, everything I did. I had no autonomy or control in what I did. And that is a classification issue. I was filing as an independent contractor, but really I was an employee. I forget the word full-time, part-time employee. I was an employee because we don't distinguish full-time, part-time. So in some instances, if you believe, or if you as an employer are hiring people and calling them independent contractors and they go to the Illinois Department of Labor, I can't do anything. I can't classify, misclassify. They could go to the Illinois Department of Labor and say, listen, I'm misclassified. They're taking away my ability to generate sick time, paid time off, all these things as an employee by calling me an independent contractor. Oh, now I see Muhammad said, yes, you are a little fast a long time ago. And I never slowed down. I'll try to slow down. It's a little late for that, Andy. So misclassification violations go to the Illinois Department of Labor. The Office of Labor Standards does not have power over those. However, if there is domestic work, which by definition, there are a list of things that meet the definition of domestic work, I don't care if you file a 1099, you don't file anything, a W-2, W-4, whatever. If the work is domestic work, then it is covered under the minimum wage and paid sick leave ordinance in Chicago. Anyone else have any examples of wage theft from the audience? This is your chance. Any examples of wage theft you'd like to share? If I could take a sip of water now. I'll keep moving and hopefully we'll see a question, but that doesn't mean you're not listening. So let's continue. Tips. To be more specific on the issue of tips. Tip regulations under the Fair Labor Standards Act. The parts of this rule became effective in April 2021. An employer cannot keep employees' tips under any circumstances. Managers and supervisors also may not keep tips received by employees, including through tip pool. So you got all the workers and they're in a tip pool, and the barbacks get X% and the bartenders get Y% and the servers get Z%, or it's based on what portion of the bill they work on, or maybe the server gets this amount and then you recommend that they all pay out a certain way. Managers and supervisors may not keep tips. Don't do it. It's that simple. I could see the case and refer it to the USDOL. I can also go after it as wage theft. An employer that pays a full minimum wage and takes no tip credit may allow employees who are not tipped employees, for example, cooks and dishwashers, to participate in the tip pool. Now that is creative, not often used. So let's read it again. An employer that pays the full minimum wage and takes no tip credit may allow employees who are not tipped employees, cooks, dishwashers, to participate in the tip pool. So everybody's getting the full minimum wage. Basically, in this restaurant, there's no tips. I mean, everybody gets a full minimum wage. There are tips, but I'm paying everybody the full minimum wage because I value them and I'm going to share in the profits. So I also want cooks and dishwashers to share in it because all the profits go to everybody. That would be something you want to put into writing so that there is an allegation that non-tipped workers are sharing in the tip pool. It's easily established. If you figure out that they're paying the full minimum wage, it changes the conversation. An employer that collects tips to facilitate a mandatory tip pool generally must fully redistribute the tips within the pay period. We've got one now. Well, it's a live one. The owner, pays out at the end of the month tips. And he says, you know what, Susie, you did a really good job this month. I'm going to give you $900 in tips. And you know what, Andy? You missed a couple of days, unrelated to whether or not I earned the tips. You missed a couple of days and you were late a couple of days. I'm giving you $700. And you know what, Betty Jean? I'm not giving you any tips because you've been divisive. So he has these arbitrary reasons for diminishing the amount that an employee gets at the end of the month. And the other part is right here. They should get their tips within the pay period. The owner can't hold the tips, and it calls into question, wait, how many tips are you really getting? Do we have any transparency? What tips were brought in and who got them? That's where I would be. Subpoena to cover the records. I command you to produce records to establish who was paid what came in the house, and how was it paid out. And if you don't keep records, it's a records retention violation. Employers that do not take a tip credit, but collect employees' tips to operate a mandatory tip pool must maintain and preserve payroll and other records containing information on each employee who received, seems like it's unconjugated, who receives tips in the weekly or monthly amount reported by the employee to the employer of tips received. I just said that. It's as if the Fair Labor Standards Act, the USDOL, knew I was coming. You got to keep records. And that's what we have. We also have record retentions. So I know a young business, it's just lucky the lights are on. You get the license, it was a lot of work. You get the employees, you're working on outreach. You got some sort of, one of my friends has, call him a friend, but I've known him for maybe at least 25 years. Has a sandwich shop on the West Loop, and he's got this wonderful social media presence. And he does collaborations, he makes subs, there's collaborations with like a pizza oven guys, and they use his ingredients and they make pizzas on the street. Or they do sweatshirts. I bought a couple sweatshirts. I'm on the waiting list, but a couple sweatshirts. Got a collaboration with a local artist for sweatshirts. The social media presence is popping. I don't know fully whether or not who gets tips and how, but usually what we do is complaint driven. Usually. We can also drive subpoenas and targeted industries based on a need. So one of the issues is who's a covered employee. I've probably already done this, but I just want to reiterate it, emphasize it, and talk about it. Remember I said, forget full-time, part-time. A covered employee is anyone who in any 2-week period works at least 2 hours for an employer while physically present in Chicago. There are certain exceptions. If it's federal, like if you are a truck driver that moves between states, generally it's not work performed in Chicago. There's certain professions that are excluded, but generally if the work is performed in Chicago, oh, this is a really good question from John. I don't own a brick and mortar establishment, parentheses, yet, close paren. And I really appreciate this because I'm learning what needs to be done by law. My question is there a standard app or software to use when maintaining tip records? That is such a good question. I don't know. I know that payroll processors, you can pay a fee to kind of figure out tips. You know what I would do? I would just call up the Illinois Restaurant Association. Really, They've got a wonderful outreach and education, but they're really well known. Sam Toya is like the president and CEO, and there are a couple other people that work with him. If you reach out to the Illinois Restaurant Association and say, listen, I'm just looking for some ideas on how to kind of manage payroll related to tips. And I'm sure the Illinois Restaurant Association would be the place to go. That's such a good question, John. And if that doesn't work, you can email me, and there's an email, just say, hey, listen, BACP labor standards, cityofchicago.org. I was at the webinar and I got a question. And that goes to all of you. If you have questions you don't want to post here, you can always post them and send them directly to BACP labor standards at cityofchicago.org. And we have our crack team of investigators waiting in the wings for your questions. Not everybody wants to put their question in the chat. Some of you are still awake, but I'll keep moving. And you know, that question down below, I've already said it so many times, you know it. Do part-time workers get a minimum wage and paid sick leave? We don't distinguish part-time. If you work 2 weeks, at least 2 hours, physically present in Chicago, minimum wage. And so, you know, we have some businesses like, you know, we've got most of our employees are in, I always use Joliet. Most of our employees are in Whiting, Hammond, Michigan State. I ride my bike, so everything on the collars. And the worker, I've got most of my employees over here, but I said one worker is City of Chicago. She's working remotely. She's working in Chicago. If she's working in Chicago, there go my arms again. The home rule wraps its arms around the worker. And if you're physically present in Chicago, you have to pay them the Chicago minimum wage, not travel time, work time, not commuting time, work time. Whew, that's enough on minimum wage, wage theft. Let's talk about paid sick leave. It requires paid leave for medical or safety reasons under MCC, Municipal Code of Chicago, section 6105. We moved it all to Title VI, which is the worker protection section. So the Cook County, the Chicago Commission on Human Relations, discrimination housing, harassment, that department and the Office of Labor Standards, we live in that Title VI worker protection section. And there's a section on paid sick leave under the minimum wage and paid sick leave. And the rules are simple. It's about accrual, rollover, and use. I didn't put it, it's out of order. Come on, Andy, stick to the script. Earning leave. Every 40 hours I work, I earn 1 hour sick leave. I only work 10 hours a week. So if you work 40 hours in 1 month, you earn 1 hour. And in 12 months, you would earn 12 hours. But if I work 40 hours in 40 weeks, I will earn 40 hours of paid sick leave. Wait a minute. If I'm a tip worker, do I get paid the tip amount or I get the full minimum wage? You should get the full minimum wage. If you're a tip worker, they have to make you whole, so you get the full minimum wage. That's a little nuance there that doesn't always get recognized by the smaller employers. And the bigger employers act like they didn't know. I'm exaggerating for effect there. That would be something you want to email us about. Like, wait a minute, I got tip workers, I'm going to pay them sick leave. Do I have to pay the tipped wage? Do I have to pay the full minimum wage when they take time off? Well, if I'm off, don't I get the wage? Don't I get the full minimum wage? Because if I were there, I would earn the full minimum wage. You get the full minimum wage. That's what tip workers get. They're supposed to earn the full minimum wage. And if the employer, and if they don't, like my son was working on the riverboats, he always got more than minimum wage. But the days that it rained or whatever, he didn't make the full minimum wage. They're supposed to supplement his wages to make sure over the life of the week, during the 40 hours he worked, he earned $15.40 an hour. So if he earned less because he was getting the tip credit, like $13 or whatever he got paid less, they would have to make up that gap in the week that it occurred. Use. There's earning, which is accrual. There's use. I should just use accrual and use, but we try to put things in plain language. You can use, that's earning. You can earn up to 40 hours in the first year, and you can use 40 hours the first year. Up to 60 hours during the second 12-month period may be used. There's some discussion about that, but it comes from carryover. So the first year I'm there, I earn 40 hours of sick leave. I work like crazy. I don't take any time off. I like money. And I don't want to, I just don't, I don't get sick. I like work. I enjoy my job. I enjoy my coworkers, I'm part of a team. It's a great place to work. I never take any sick leave. I figure it out, and maybe I swap shifts, but I don't take any sick leave. That first year, I've earned 40 hours on the books. At the end of the year, half of that time rolls over to the new year. So on January 1st, I've got 20 hours up front in the books. And then 40 more weeks, I can earn 40 more. There's a discussion about whether or not that means you could use 60. The use is really, you can use 40 hours a year, but you can still roll over the 20 and you get to 40 much sooner. In certain cases, up to 40 hours may be carried over. That's related to Family Medical Leave Act. I forgot to read this top part. Employers must provide employees with paid sick leave to care for themselves or a family member if they work at least 80 hours within a 120-day period. So here's the question. My son and his partner are going to have a baby. Can I take paternity leave to be off with that family member's child when they are born? Ooh. And there's been a recent amendment to city policy and procedure related to parental leave. Forget maternity and paternity. It should be equal. We don't distinguish on the basis of sex, right? So parental leave, forget paternity, parental leave. Can I take parental leave to take care of my grandson or granddaughter? I'm hoping it's a grandson or a granddaughter. I don't care. I just want a healthy baby, right? And so you would have to look at the municipal code of Chicago to see if you could take parental leave for caring for your grandchild under this, if you were a city employee. Now that doesn't apply to all businesses. Businesses are free to exceed the minimum. So the city sets the minimum. City sets the minimum. So you're supposed to earn up to 40 hours of sick leave. You must carry over at least 20. A lot of employers say, you know what, we're just going to front load it. Year one, you're going to get 40 hours of sick leave. Why are we going to worry about accruing and counting? You get 40 hours a year. Okay, dude? Do that. You get 40 hours a year. You start January 1, you're going to get it. You start July, whatever, you're going to get less. We're going to amortize it. We're going to stretch it out. But year two of employment, you'll get 60 hours. Year 3, you're going to get 80 hours. Year 4, you get more. In some places, we'll call it paid time off, paid sick leave, vacation leave. If it's called sick leave, it's sick leave. It's called vacation leave, it's vacation leave. If it's called paid time off, and it's equivalent to sick leave, meaning that the definition of family member is the same, it must be a true equivalent, then that sets the minimum bar. So some places say, you know what, we're going to call it paid time. And that includes, but it's not limited to, vacation time, sick time. And we don't care when or how you take it. You just take it. It's your time. It's time. If it meets the minimum bar set by the ordinance, then we cannot call that a violation. So I think the point there is, if you're not a practitioner in the area, maybe you should talk or seek legal counsel before you implement a sick leave, paid leave, vacation leave policy. Because there are also policies and state laws about paying out vacation leave when someone leaves, paying out sick leave as someone leaves. Some of it is at the discretion of the employer. So if you have 40 hours on the books, at the discretion of the employer, they can pay it out. Unless there's a specific policy that says when you leave, you get your paid leave sick up. Vacation leave, however, is a property. It is the employees. So vacation leave must be paid out. So if you have a combination PTO, vacation leave, sick leave, then you might have to pay it out when the employees leave. If there's a transition of company, like franchise owner 1 buys Andy's Taqueria from franchise owner 2, and the sick leave on the books transfers over, you can say, oh, nobody's got any sick leave, sorry. I'm the new owner. If it's just a transition, you transfer ownership from one owner to the other, the second owner has to take on the sick leave on the books of the first employee. I know, that's technical. Any questions on sick leave? I'll try to give you some. Any questions on sick leave? Any questions on sick leave? Have all voted who wish. Have all voted who wish. Let's go on. Recent trends. Unfortunately, recently, we've got companies with up to 50 or more employees, and there is no paid sick leave whatsoever. There is on the near west side a business that does food preparation, food packaging, and they ship out to locations all over the city. And the workers are working 40, 60, 80, can you believe this? 80, and some we found on their paychecks, 100 hours in a week. I don't know how you work 100 hours in a week, but they were getting paid 100 hours of work in a week. So they're not complaining about sick leave. Oh, wait a minute, they did complain, right? Someone complained, and the owner's like, what are you talking about? We have sick leave. It's like, no, I personally interviewed your Spanish-speaking workers, and one after one after one said, sick leave? No, none, zero, never. And in fact, they said, yeah, the woman, who's the owner, they called her the woman, la señora dijo que no, no hay. No, said the owner, no, there isn't sick leave, no. Just so you know, I'm Mexican on one side, so sometimes I'll jump between Spanish and English. And I interview the workers myself in many of the Spanish-speaking cases. So if you have Spanish-speaking workers, our office will be reaching out to them in Spanish, in email, in text, and phone. And our goal is to turn the tables of the case. If we issue a subpoena, we start communicating with the workers. So the owner's like, oh, we know what this is. We know that we have sick leave. Yep, we do. And the lawyer's like, yeah, the owner told me they have sick leave. It's like, yeah, well, that's nice. Because I personally talked to 30 workers. Me and Marcia and the other investigators worked, and we talked. We did 30 interviews. And all of them corroborate what the complainant said. We get one complaint, we investigate as to all the workers. No one's getting sick leave because the owner, the female, is telling them we don't have sick leave. So you might have it on the books, but if there's a policy, back to this manager, good policy on paper, no implementation. Second bullet, 100 to 1,000 employees. Can you believe a business that had, our largest settlement ever was for, it's public knowledge, so Burger King had a franchise with like 30 Chicago locations of Burger King, was not giving any paid sick leave whatsoever. The same entity also has stores in, they're one of the largest in the Midwest, has entities in Minneapolis, and the Minneapolis Office of Labor Standards says, hey, Andy. Hey, Brian, how are you? Pretty good, man. I was just wondering, how did your negotiation go with Burger King? Because we got a complaint for the same franchise owner. I'm like, it went quite well. Once we got their records and we started interviewing employees, it was clear from the wage records that there was no paid sick leave whatsoever. When we talked to a sampling of the employees, no one said their sick leave, and their accountant admitted, yeah, we just didn't have it. So I don't know how they didn't have it in Minneapolis also, but that's where they're at next. So if you hide from the law, we're going to find you. Just comply. We'll comply now. And if you need help, we're here to help. Smallest employers, here's what some of you on here are what I would call the smallest employers. You're trying really hard to set up your business. You're close and or you've got a storefront. Sometimes you differentiate between full and part-time employees. They're just employees. If they only work 10 hours a week, then just accrue. You set up an accrual method, and people might not earn a lot of paid sick leave, but they earn it. So it might take them 40 weeks to earn 10 hours of sick leave. 10 hours of sick leave is like a day and 2 hours, right? So let them accrue. It might cost to put it on your payroll records, but you can also do a hand tabulation, communicate with the workers. Say, listen, here's our sick leave policy. It complies with the Chicago minimum wage and paid sick leave ordinance. If you have to take time off, here's how you have to do it. You can't require a note until day 3, day 1 and day 2. They don't have to produce a note that they're sick. They're sick. I'm calling off sick. Day 3, I need a note, a certification. Whether or not it's self-certification, back when the pandemic was hot and really popping, doctors would not see people. We would allow people to self-certify that I'm sick, because we don't want you leaving your house. You stay in your house. You self-certify. Back to work. Trending questions. The questions from HR professionals, from attorneys advising businesses who are starting up. Wait a minute. Can I front load all the sick leave? And if I'm FMLA eligible, do I have to roll over if I'm front loading part of it? There's FMLA language, Family Medical Leave Act. And if you're Family Medical Leave Act eligible, you're larger. And so the ordinance requires of the 40 that you had on the books, half roll over. FMLA requires if you're FMLA eligible, you also have to roll over 40 hours to be used exclusively for FMLA purposes. I could probably read, if I just put that up on the screen, you'll see how it causes consternation. Does anyone have any questions? I did answer the one question. It's still up there. So the preceding slide, I get emails a lot about, can you please explain accrual? Well, what if we front load? How much do we roll over? What about FMLA? And so my answer to that is keep paid sick leave separate from FMLA in your mind. Bifurcate, split, keep them separate, partition them off. Paid sick leave shall begin to accrue either on the first calendar day after the commencement of employment or July 1, 2017, whichever's later. So after the first day, you begin to accrue. However, for every 40 hours worked, the covered employee shall accrue 1 hour of sick leave. You've heard me say that 5 or 6 times. You know it now. It's ingrained in your mind. Paid sick leave shall accrue only in hour increments. Problem is, periodically on the paycheck, if you get a payroll processor, it just accrues if you work 46.2 hours. It's not a whole number. It'll show as a fractional. We're not going to shut you down because the pay stub shows that Andy earned 15.27 hours of sick leave. You can round up because that's what you should do, but I don't know that that's going to get you shut down. We're not going to do a stop work order or cease and desist. We're not going to go into court and stop you from working because your accrual method is not in hourly increments. It should be though. And if it can be, it should be. You can also pay your HR person to run accruals so people know, okay, I've worked 160 hours this month. All right, cool. I have 4 hours this month. In 2 months, I'll have 8 hours. In 3 months, I'll have 12 hours. People should know, doing the math, like how much sick time do I have on the books? It's theirs. The better you communicate with them about the benefits, the more happy they will be, the more they will show up. And when they're sick, they'll be sick. You don't want them coming to work when they're sick, do you? People that came to work sick extended the pandemic. 3, a covered employee who's exempt from overtime requirements under this chapter shall be assumed to work 40 hours in each work week for purpose of paid sick leave unless the normal work, because that was really, I think it was Sudiana, or the question in the beginning, Sudina, was about, exempt from overtime requirements. If you're exempt from overtime, then you're assumed to work 40 hours a week, because if you're a salaried employee, you might work 80 hours a week or 60 hours, or 70 hours or 90 hours a week. You only accrue 1 hour for each work week worked. All right, so here's where the challenge is. At the end of the covered employee's 12-month accrual period, the person shall be allowed to carry over for the following 12-month period, half. We know that. If you have 40, you carry over 20. If you have 30, because you've used some, you carry over 15. If it's a fraction, round up. 6, if an employer is subject to the Family Medical Leave Act, each of the covered employees shall be allowed at the end of the 12-month period to carry over up to 40 hours of employees' unused paid sick leave, in addition to the carryover allowed in subsection 045 to use exclusively for Family Medical Leave Act purposes. If you're big enough to have the Family Medical Leave Act, you have someone there who handles those. It's federal law. Family Medical Leave Act there's an application and a review and a process that applies. If you have questions about this particular section, we could discuss at another forum and or via email or phone how to make sure that you're FMLA compliant with Chicago's paid sick leave. Any questions? Oh, we're at the 60-minute mark, so I don't want to bore you much more. The Fair Workweek law is a scheduling law. It now requires, for certain industries, there are 7, manufacturing, hotels, healthcare, building services, restaurants, retail, warehouse services, that you give your workers schedules with 14 days notice. It means, however, that you've got to have 50 people working as covered employees in that industry and 100 total employees. If they're restaurants, it means you're tied to a global franchise. Like if you are Jimmy John's, and you have 4 franchises in the city of Chicago, we use the employee count from Jimmy John's Global because that's the business is Jimmy John's Global. You're doing business as Jimmy John's locally as a franchise owner, then you have to have 4 franchise locations and tied to 30 global in the business. It's that simple. It means that people who get schedules should get their schedules 14 days in advance. If they change your schedules less than 14 days, like, hey, you know what, Andy, I know we put you on the schedule for Monday to Friday, but we need you Tuesday to Saturday. So they dropped Monday, they added Saturday. You would get 2 hours of predictability pay for those changes to your schedule because you rely on the schedule. You rely on your schedule to plan your life, to take care of your kids, to take care of your family, to take care of your family/dogs, or just to be free. Because you might have a life outside of work. Contrary to the opinion of some businesses, your life ends when you clock out for many of us. Not my usual. You can also decline a shift. So, hey, Andy, we want to switch you from Monday to Friday to Tuesday to Saturday. You know what? I'm going to decline the shift change. I've already got babysitters lined up Monday to Friday. I don't have a babysitter for Saturday and I can't get one. It's totally impossible. I'm going to decline the shift change. This applies to larger employers because they've got the wherewithal, the resources to plan and schedule people in advance. There's something called right to rest. And that means if you are required to work a shift less than 10 hours from the previous shift, you get 1.25 times pay. If your shifts are canceled or cut, you're sent home like, hey, you know what, Andy, it's Friday, not really busy. Why don't you go home? They cut 4 hours of your workday off. You would be entitled to half of that pay for those hours that were cut. The Fair Workweek Ordinance, well, there's the contact information there. Eric, the contact information, oh, it's tiny. My phone is, well, the office line is 744-2211. Because I know some of you are going. Our email is BACP Labor Standards at City of Chicago, chicago.org. You know, I could go on for days. You've seen, I do not lack passion for this area of the law. My goal is that anyone who's attended just feels a little more comfortable with setting up a policy for minimum wage, paid sick leave, making sure you're compliant, and knowing who to ask if you have questions. One of the emerging trends is this: workers know their rights. They look at these laws, they know how to exercise their rights. They're not scared of you. They're not. In the old days, workers were very timid. Workers now in hotels and restaurants, undocumented workers, know that we're going to wrap our arms around them and protect them if they advocate for rights. Hotels and restaurants, and just restaurants in general, workers are organizing. And if they're not organizing, they're reading and listening to the law. And so better be in compliance than get caught without anything, because we will go back in time and reconstruct. We could go all the way back to 2017 for minimum wage violations. And so laws are designed to protect the good employers and the good employees. There's no refuge for those that avoid the law. Let's see. Those are the definitions. I'm going to cut it now. I think you've got plenty. We receive complaints, we intake and triage. That triage is a typo. We investigate cases through subpoenas. We try to settle cases. But if you ever get a subpoena from us, we're going to work with you to make sure you get into compliance. If it breaks down, we'll take the case to administrative hearings, mayor's license disciplinary commission. If you're big and it's really worth it, we'll take it all the way to circuit court, where the enforcement actions are much broader. Oh, I think I lost my volume. Hold on. No, I still have my volume. Can you guys hear me? All right. Well, you can see the closed captioning. I think I'm going to cut it here. If anyone has any questions, feel free to post them. But at the hour mark, it can become a little challenging. John asked the questions about, couldn't a person who's sick connect via video show that they're still sick? That is a good hypothetical. I'm not prepared to answer, John. I mean, it's an interesting hypothetical. So all you young business owners, young in time, not in age, all you new and emerging businesses, the city's waiting for you. There are 77 neighborhoods that are looking for you to put up your shop and to begin selling things designed for your local communities. I urge you to take part in this magnificent recovery. Be bold, be fair, and people will come to you. Be real. And if you have questions or problems and you're looking on with information on how to set up a business, BACP's got it. I'm here for the labor law issues. I want to thank you all for attending. That's really all I have. I think Stella will close us out with some final admonitions, just as an FYI. Stella?
Yeah, I'm here. If you would like to receive credit for today's webinar, please send an email to bacpoutreach@cityofchicago.org. To join our certificate program, please send an email to bacpoutreach and let us know that you would like to participate in our certificate program. We are scheduled for another webinar on Friday at 9:30. To register, please visit chicago.gov/business education. Thank you, Andy.
Bye, Stella. Bye, everybody. Be safe.